This conference will now be recorded.
Well, good evening, everybody. Thank you for participating. This is Herzl Law's presentation on the topic being, is it time to amend your governing documents? My name is Matt Heron. I'm with Herzl Law. This presentation is divided up into three separate parts. And as you can imagine, they're each driven by the governing documents of your corporation, which are in the governing documents of your different subdivisions and condominiums and different projects that you have. The way we've separated out is that the first portion of this is going to be dealing with the Articles of Incorporation. And the overarching question for each of you, the takeaway is going to be, do we need to amend our Articles of Incorporation? The next part of it, the second portion, is going to be dedicated to what we'll term the governing documents. You may hear those referred to as governing documents, but they're really referring to, in the context of a condominium, a master deed and condominium bylaws, and in the context of a subdivision or a project that is not a condominium, a declaration or covenants of conditions and restrictions or deed restrictions. So the overarching question for that second portion is going to be whether those need to be amended. And the third category is going to be dealing with rules and regulations. How do you adopt, how do you enforce rules and regulations, and what can a board do? Each of these are approached fundamentally differently when it comes to amendment and changing. In broad strokes, the Articles of Incorporation deal with the company itself, the corporation. Those can be amended by a vote of the members of the corporation, and they're generally disassociated with the land. It deals with how the corporation, the company itself, operates. When you're dealing with the governing documents, you're dealing in that instance with the connection between the documents and the land and how the land can be used by the individuals that live there. Those are almost always going to be required to be amended by a vote of those of the co-owners. And in the context of a condominium, there's generally two different parts to it. There's your master deed, there's your bylaws, which are almost always Exhibit A to the master deed, and then your subdivision plan, which is Exhibit B. Just for purposes of what we'll be talking about today, Exhibit B, the subdivision plan, are the drawings at the back. They're the engineer documents, they're the surveys, or the site plan. Most of what we're talking about is not going to relate to those documents. It is possible, depending upon the scope of your amendment project, that you might have that, but that's something that would be usually outside the scope of an ordinary issue. I do have somebody that's indicated that they have audio questions. If you do have issues with audio, please let me know in the comments. That's really the only way I'm going to be able to tell. But for the most part, since I've only got one person saying that, I am going to assume that you can hear. With respect to rules and regulations are generally adopted when they're able to be adopted by the board directly. These are matters that are within the discretion of the board. They can't exceed the authority granted by the governing documents, but they're used by a board to implement or interpret existing restrictions or provisions that exist in the governing documents. We're kind of in a unique time period with the impact of coronavirus, COVID-19. And as you can imagine, I'm actually presenting this from my home rather than work. So it's an impact that we're all feeling. I have added a couple slides to this particular presentation that deal with that issue in an attempt to give boards some ammunition in being able to protect themselves in the community as much as is possible. So with that, they're turning to the first slide, which deals with the Articles of Incorporation. The Articles of Incorporation are what are maintained with the state of Michigan. They are originally filed in order to create the company, and they're the documents that, in addition to creating it, they need to be maintained, and the annual reports need to be filed with the state each year in order to maintain the good status of the corporation. If annual reports are not filed continually, then after a certain period of years, it's supposed to be 2, the state of Michigan may actually automatically dissolve the corporation. So it's important to keep up from a filing standpoint with the Articles of Incorporation. Generally, for our purposes, as we deal with the condominium associations and homeowner associations, they're almost always going to be nonprofit. You're dealing with nonprofit corporations that have volunteer boards of directors. The real breakpoint, or at least a separation between the types of corporations and how the original filing can sometimes get people into trouble, is there are mandatory associations and there are voluntary associations. In general, the vast majority of homeowner associations and all condominium associations are going to be mandatory. In certain instances, there will be homeowner associations that are voluntary, which are a kind of a unique animal. And those are going to kind of gauge and affect how the different board of directors can operate. But the site up here is how you can find and locate your particular corporation if you're interested. So on the first example, I thought that I would start with an example to get right into it to see if there are different ways that you can see how the Articles of Incorporation may affect what you want to do. So here's the first example. Actions without meeting. Don, Nancy, and Chuck agree that the White House Acres condominium condo bylaws should be amended to prevent members from emailing out fake association newsletters. Don says that the Michigan Nonprofit Corporation Act permits the association to amend the condominium bylaws without holding a meeting. 70% of the members send in ballots approving the amendment. Has the amendment been validly adopted? So that's the question. This is one of those breakpoints. Feel free to send in your chats if you'd like to, but the question that I have is whether or not this particular amendment has been validly adopted. So I'll give it a couple seconds. All right, we've got one. One person says no. We've got another one that says no. We got another one that says the documents. I'll ask you to stay muted. So it looks like we have not tricked anybody. Nope, everybody has come back. Those that are saying no, we have one that says yes. But the answer here is that this vote is likely not valid if there is what's called no action without meeting provision in the bylaws that would permit the use of consents. The Nonprofit Corporation Act contemplates, when it was originally drafted, similar to the Model Business Corporation Act, that the companies would business of the company would take place at a meeting. There would be an opportunity for exchange of ideas, there would be discussion, and there would be a vote at a meeting. Eventually, though, there were efforts that were adopted in order to streamline or make it easier for a company to act or for a corporation to act. And that's what's called an action without meeting provision. But in order to be able to utilize an action without meeting provision, that provision and that right must be contained in the bylaws of the corporation. And there's in essence 3 different types. In this one, we use the idea of a consent. And those are contained in the Nonprofit Corporation Act, MCL 450.2407, 08, and 09, which are the 3 main mechanisms. You can use written consents, which don't require notice, but require signed and dated documents. The most common of these, though, are to use what's called ballots, which is where a notice is sent out, which includes a ballot in a manner very similar to a notice for an association meeting. It just includes a ballot. That's very common, and sometimes it's done without the correct provision, which would open up the particular matter being voted upon to collateral attack. So the purpose for this particular exercise was to go over the concept to say, look, this is a useful tool. It can be used by a company or an association, especially in today's busy times where it may not be possible to get everybody into a meeting on a busy weekday or weeknight or during the weekend. In the presence of an action without meeting provision, if you don't have it, can be useful to getting to allowing the corporation itself to take action. So the significance of this is take a look at your Articles of Incorporation. If you don't have an action without meeting provision and you want it, then it's something that you should look at and consider. All right. So the next example, this one is a little bit different. this is the last one basically dealt with form and procedure, how the company can operate, how the association itself can function. This one is a little bit different because it deals with a fundamental question of liability and substantive issues of corporate governance. So here's the issue. Don is the president of the White House Acres condominium. He is on the board with Nancy and Chuck. The condominium has a problem with trespassers. The board votes to build a fence around the perimeter of the condo. Don loses 2-1. Don does not like the decision as he claims that the fence is necessary for safety and to preserve property values. Don consults with the association's attorney, Michael, a general practitioner with only 3 clients. Michael tells Don that he can build the fence anyway. Don spends $100,000 to build the fence. Nancy and Chuck sue Don for spending the $100,000 on the fence. So the overarching question, which I'll take answers via chat, is Don liable personally for building the fence? Oh, Shannon Murray, there you go. All right, so we've got a couple. We've got yes, we've got no, we've got a couple no. We've got another no. So this is great. I love seeing these answers, these responses. This is a great way for you guys to can give me your thoughts on it. Ultimately, though, at least how I would expect this to come out is that Don is probably not going to be liable, as was indicated by one of the commenters, because he relied on the advice of a third-party professional. And that's contained in MCL 450.2541, which is the same provision of the Nonprofit Corporation Act that describes the general standard of care of a director. But the overarching principle here, and one of the ways that Don might get himself in trouble, is that exception to liability, or at least that provision that allows Don to rely upon an expert's advice, is not applicable if it was not reasonable for Don to believe that the issue was within Michael's competence. If that's the case, basically, if Don knows that the opinion is given by somebody not competent in that particular field, he may have not been able to rely on it. And so in this particular question, Michael, a general practitioner with only 3 clients, Don's reliance upon Michael's advice in that instance might give him some issues, at least under the general provisions regarding director liability. That's an important provision that directors should rely on anyways going forward. Most property managers will advise the board of that particular issue, and oftentimes will encourage a board to seek the advice of third parties, largely for that reason, trying to get the board to rely upon and make decisions based upon the advice of third parties. So in general, the reliance upon the advice of third parties can help. However, our analysis doesn't end simply with the question of whether or not the board member has relied upon the advice of third parties, or whether they satisfy the status of due care. Because we're talking about amendments, we actually want to look at what the contents of the documents are and whether the documents incorporate the most recent provisions of the Nonprofit Corporation Act dealing with director and volunteer liability. Recently, in 2015, the Nonprofit Corporation Act was amended to allow nonprofit corporations to further limit the liability of their directors and volunteers. In essence, these amendments were adopted by recognition of the legislature that most participants on nonprofit corporation boards are going to be volunteers, and that the possibility and the risk of financial liability to those volunteers could be a disincentive to serve on that board. And if you are having issues with the access, we have Becca who will be assisting you with that. But the main issue here is that the legislature wanted to encourage people to participate, and it wanted to create the ability of a corporation to limit the liability of those volunteers further than it had been prior to 2015. So in essence, if a corporation has limited the liability to the extent permitted by a section 2209C, then as a practical matter, the individual director or volunteer would only be liable to the extent, as a practical matter, that they've either committed an intentional harm, a criminal act, or derived a financial benefit from their own actions. So you can see that these are each pretty significant events that would warrant director liability, but financial liability for those directors has been largely excluded if these provisions have been adopted. So from the perspective of the existing board of directors, what we recommend and suggest is that you evaluate the limitations of liability, if any, that exist in your current articles of incorporation to see if they are consistent both with what you want and consistent and coextensive with the limitations of liability permitted by the Nonprofit Corporation Act. Because if they are not, the risk is that your articles of incorporation may be permitting director liability that you don't expect. And aside from the concept of risk, this can also have an impact on premiums and the amount of premiums for direct D&O insurance if that were to be purchased. So those are basically two different issues that we want to take a look at from the Articles of Incorporation perspective as to two of the most significant reasons to make amendments to the articles. One is to streamline the actions of the company and the actions of the corporation through ensuring that you have an action without meeting provision. And the second is from the perspective of a limitation of liability, attempting to ensure that the articles of incorporation limit the liability either to the furthest extent possible permitted by the Nonprofit Act, or at least in a manner that is desired by the corporation. So at least with respect to the articles of incorporation, those are the topics that I wanted to cover. If there's a specific question, I will take about 2 minutes to try to address questions on the articles of incorporation. Feel free to throw me a chat in on this particular issue with either the articles of incorporation, action without meeting, or director liability. If I can answer it, I'll spend about another 1 to 2 minutes and answer it. I think I did a very good job. I haven't received any chats on that one. All right, so turning to governing documents. So governing documents, these are generally recorded, whereas your articles of incorporation are filed with the state and can generally be amended by a vote of the members of the corporation. Your governing documents that are referred to here are generally going to be more difficult to amend, and they usually are going to be and should be recorded with the Register of Deeds of the county in which you're located. The reason these are recorded with the Register of Deeds is they're intended to place prospective purchasers and current owners on notice of the types of restrictions that can apply and the obligations of the owners as to the land. Basically, what are the mandatory obligations? What are they going to have to do as a result of owning the land? And then also, what can't they do? What are the restrictions? What are those things that they may be prohibited from doing or limited in doing in their ownership? Before I get into some of the specifics on it, there is an overarching, there's a case called Conlon versus Upton that describes the relationship between governing documents, the impact of the recording of these documents, and a board's effort to adopt rules and regulations to restrict further actions of the co-owners or to interpret and implement the restrictions. Governing documents are the bylaws, and they are going to govern the actions of the individuals that live in or own units or lots. From an amendment perspective, there's going to be a handful of reasons, and there are others, but these are the most common reasons that you may want to evaluate whether or not you want to go through an amendment process. In essence, these are going to be changes in the law. Maybe there have been changes in the law since the last time, since the documents were originally drafted, or since they've been amended. Maybe you have conflicting provisions. In many instances, the master deed and condominium bylaws are drafted separately. Sometimes they come from form documents, and in an effort to tailor specific provisions to the specifics of a particular project, there may be inconsistencies that are developed between those documents. So An amendment process can sometimes be used to attempt to fix those inconsistencies. There also may be developer issues, especially after the transitional control period has concluded and the management of the condominium has been handed over to the association. Maybe there's legalese, you just can't understand what was drafted, and some mad hat attorney came in with all their favorite therefores, wherefores, and other fancy terms. Or maybe just frankly, the documents are outdated. Maybe they reflect a different time and they don't actually reflect issues that you're presented with. Just to give you some examples of each, with respect to changes in the law, we've had something related to satellite dishes, something called the Otard Rule, which is the over-the-air reception device rule, which came about in the late 1990s. You have different provisions that permit electronic notice, electronic voting, if the documents provide and consents obtained. Limitations of director liability we've already gone over. That is a result of a change in the law in the Nonprofit Corporation Act, and action without meeting. And an interesting one is marijuana usage. Not necessarily that there's a clear, bright line on this, but marijuana laws at a state level have changed, and depending upon what your documents say, you may have a present conflict between what the association wants to do and what the association has to do as a result of the change in the law. From an outdated document standpoint, maybe you have issues related to solar panels, electronic vehicle charging stations, drones, or generators. You know, those issues and those items may not have been around or as prevalent as they are back at the time that the documents were first drafted. And so maybe it's worthwhile to take a look at your documents to see if you want to address those in a certain way. There are other things also that maybe need to be addressed. Turning specifically and kind of looking at it from the perspective of a condominium, if you look at your master deed, there are certain things that may just not be very well defined. In many instances, you've got general common elements and limited common elements. You would like to see that these are very well defined and there's a clear distinction between those. So one thing you may want to take a look at is do our documents accurately reflect what we understand to be the difference between units and limited common elements and general common elements. And you want percentages of value, are those accurate? Do the easements, the description of the easements in the master deed, are those accurate? Probably the most significant one that is, at least the one that we see that's most usually wanted to be changed, is responsibility for repair. In general, an amendment process isn't used to change or alter the differences between general common elements and limited common elements, but the amendment process can be used to change the responsibility for repair and replacement. Over time, maybe the sensibilities of the association change as to what the responsibility of the co-owner should be for maintaining different things versus what the responsibility of the association should be. An amendment process can be used to address that. More recently, the overarching approach has been to evaluate who, as between the association and the co-owner, is in the best position to both maintain and insure a particular item, and to ensure that the documents reflect that position. This comes as somewhat of a change from the way in the 60s and 70s documents were drafted to attempt to push more into an association responsibility and to try to collectively evaluate and have the association responsible for as much as possible. For a number of reasons, that hasn't worked out exactly as people may have wanted. And so now the trend is to see, and the tendency is to see, okay, as between the association and co-owner, who really is in the best position. So responsibility for repair and replacement can be a significant issue. And not to leave subdivisions out, these issues can also be, similar issues can present themselves with a homeowner association, especially if that homeowner association, if it's a subdivision, has common areas. Does the declaration or the covenants and restrictions, do those reflect the accurate state of how those common areas are maintained and what the association wants to be the separation and responsibility between the lot owner and the association itself? Each of these are reasons to potentially evaluate whether or not you would like to amend your document. So turning to a specific thing, and I'll just reiterate, I will try to get to specific questions at the very end, although it's possible if you do have a question, I'd like to think that we'll cover it without having to ask a question, but feel free at the end of this particular section to ask by chat. All right, so here's another question. Here's a quiz for you guys. Washington LLC is the developer for the White House Acres condominium. White House Acres has numerous leaks. Washington's attorney, Mr. Hamilton, drafted the bylaws. The bylaws require 2/3 co-owner approval for any litigation expenses. The board believes it has the authority to initiate litigation and files a complaint, as this provision is unreasonable and usurps the board's authority granted under the Michigan Nonprofit Corporation Act. Washington LLC moves to dismiss the case as a vote was never taken, meaning a vote of the co-owners was never obtained for 2/3 approval. So the question for you is this anti-lawsuit provision enforceable? Will Washington LLC's motion to dismiss likely be granted if no vote was taken? So feel free to answer. I'll take a few comments and a few questions on it or answers on it, and I'm going to give you what I expect the answer to be. All right, we've got a couple people that have said yes, so I wonder if is anybody going to say no? Okay, we do have somebody that said no. Probably take a couple more. All right, so on this one, this is actually decided. So this is there are actually a couple cases that have already been on this issue, but this provision is enforceable, and this is what's called, depending upon the side that you're on, if you're a developer, then this is called a blue sky provision. If you are on the association side, this is called an anti-lawsuit, anti-litigation provision. The issue here is that most developers, if their attorney is doing things correctly from the developer, from the limitation liability side on the developer, they are going to insert provisions in the articles of incorporation and the bylaws that limit the ability of the association to sue the developer if there is a later problem. Under this particular provision, if the association were to attempt to file a lawsuit against the developer would likely be able to get the lawsuit dismissed if no vote was taken. You can see the practical difficulties for the association. The main difficulty being that, on the one hand, they're going to have to get 2/3 approval in order to be able to actually file a lawsuit. And that's further complicated by the possibility that some of those units may still be owned by the developer. And in that case, that there's nothing that would necessarily prohibit the developer from voting their interest, which would be attempting to defeat it. The reason this is mentioned is that this anti-lawsuit provision, whether it's contained in the bylaws, as in this example, or whether it's in the articles of incorporation, which is the other possibility, is that this should be, especially once the transition period has been passed, this should be removed. So from an amendment standpoint, if you're evaluating your documents, recognize that this particular provision, if it exists, could be a significant impediment to the association's attempt to file a lawsuit. Now, it generally doesn't apply to enforcement of the bylaws or collection of assessments, but it otherwise would limit the ability of the board to file a lawsuit without getting co-owner approval. There is one slight exception that I would describe, is that many times this provision is so onerous that for example, an attorney that attempts to represent an association's capacity sometimes may be asked to provide not just a list of their experience, but a list of their clients also. Well, at least in one case, the Court of Appeals has said that that particular issue is a bridge too far. So while the 2/3 co-owner vote can be required if it's contained, the client list itself and the list of clients that would be representative of the work is not something that can be requested. But this particular provision is a big issue, and if your documents have it, you should at least evaluate whether, if you do nothing else, you want this particular provision removed. All right, so that particular example was an example of the anti-lawsuit provision. And there are numerous reasons why there may be and I'll back up to a certain extent. Many of the reasons I'm mentioning these particular issues are in the context of looking at it from the perspective of the board of directors as to whether or not the board and then the co-owners want to pursue an amendment of its documents. The purpose on the developer side of it would be whether we want to amend out that particular provision or change it. So you would need to follow, of course, your amendment requirements, but the goal of that would be to try to remove that provision. There are other developer provisions that could also apply that you also may want to remove. Some of them not necessarily as significant, but maybe not as pressing as the anti-lawsuit provision. For example, in many documents, and in most condominium documents that are drafted from the developer standpoint, the developer pays a different assessment. The developer would pay what's often called a proportionate share of expenses versus assessments. And in many instances, that's expected to be and is less than assessments. So in many instances, that's something that a board may want to take a look at. Is the assessment paying fair, at least from the association's perspective, and something that can be evaluated? If it's heavily in favor of the developer not paying assessments, and if the developer maintains ownership of units for an extended period of time, that can pose an issue. Other issues deal with what developers are supposed to do at the time the project is completed. Is there's supposed to be a consolidated master deed. That's supposed to take the original master deed plus all amendments and changes in the subdivision plan that may have occurred and record at the very end consolidated master deed that reflects the way the condominium actually looks once it's been completed. The question, though, is whether or not that actually happens. In many instances, it doesn't. So I did get one question. I'm going to generally try to save it to the end, but the question was, can the homeowners association change what I understand to be the anti-lawsuit provision if it amends its bylaws or articles? That's correct. If you comply with the amendment provision and you're able to get whatever your particular required vote is, whether it be 2/3 in the context of the bylaws and the condominium bylaws, or whatever your voting requirement is in the articles, the goal would be to try to amend your documents to have that removed. But the other issues that deal with the developer, in addition to the anti-lawsuit provisions, are the assessment exemptions, the consolidated master deed, which really tends to be more of a complication than anything else. I don't know if many of you have condominiums which are on their 20th, 21st, 22nd amendment, but they're up there and they can be somewhat cumbersome when you're attempting to figure out what the rights and responsibilities of the various parties are. In some instances, if there are a number of amendments and no consolidated master deed has been done, it may be worthwhile to do an amended and restated amendment in order to consolidate everything into one particular document. And the last provision here is, in many instances, developers will include certain rights, things it can do, things that it can do but others can't, maybe in the context of architectural control, maybe signs. Some of those can be changed and some of those cannot. The Condominium Act does state that a developer is able to reserve certain reserved rights that can't be amended. But in many instances, those development rights can be changed, because in many instances, the developer is just looking to say you can't change something or it can do something, and it would just need to be evaluated to determine whether or not it can be removed. Another complicating area along these lines, and similar to the consolidated master deed, is that in many instances, the developer will reserve to itself architectural control. It will want to dictate how things are built out, how things look, and how things appear from externally, and also sometimes as an effort to make sure that things are built in the developer's vision. And there's not per se anything necessarily wrong with that. But what sometimes happens is that the developer can sell the last lot, last unit, and fade away. There needs to be a manner, a way for the association to take over those particular rights, those particular actions and responsibilities of the developer, especially with respect to architectural control. So depending upon whether or not the documents permit it, in some instances, architectural control rights can only be assigned if there's a signed and recorded assignment executed by the developer. In those particular instances, if the developer has not signed that document, it can be somewhat problematic. And you may want to be able to you may want to look at and see if you need to amend your documents to be able to address that. So I do have one question on options to continue to build. That one I would hesitate answering, mainly because it's going to generally differ between a condominium and a subdivision. In the condominium context, the developer is going to be bound by certain timeframes set in the Condominium Act that generally, at least in Michigan, don't apply in the subdivision. So if you do have questions as to whether or not your developer is building out accurately, or whether they're improperly reserving the right to build even over extended periods of time, I'd be happy to talk to you offline or possibly at the end once this is concluded. So those are just some highlight of issues dealing with developers. So aside from developer issues, one of the simplest reasons to visit taking a look at amending your documents is the age of the documents. If you have a condominium that was formed in the early 1970s, even prior to the enactment of the Condominium Act, and your documents haven't changed, then that's likely something you should evaluate. There not only have been changes in the law that have taken place that you need to look at to see whether or not you comply with, but there's just practicalities to the time frame and the evolution of how associations manage their responsibilities that you should take a look at. The examples in this particular instance, though, and one of them I'd already mentioned, the FCC rule or the Otard Rule dealing with satellite dishes. In many instances, and I think this deals with a comment that came in many instances, you'll have documents that predate 1996 that will outright ban or prohibit satellite dishes. If you have such a document, it's likely that if the board relies on that provision and believes it has the ability to outright ban or preclude satellite dishes, that the board could be exposing itself and the association to the potential for liability, because satellite dishes that are maintained or to be constructed on either limited common elements, which are exclusive to the co-owner or the co-owner itself, the owner has certain statutory federal rights to have that and to have a satellite dish in certain circumstances. So you would need to be able to evaluate that within the context of the law. And if your documents predate 1996 for sure, and most likely even if they were drafted either shortly after or sometimes for an extended period after 1996, they may not fully evaluate and take into account the responsibilities of the association in that respect. Another issue is fair housing. Discrimination based on familial status is an issue that is coming up. I'd say more and more, but it's been relatively, not that it's more now, but they do keep coming. And the issue on this generally deals with the association's treatment of children and children's access of general common elements. Oftentimes, whether it's pools, whether it's tennis courts, but in general, if your documents carte blanche separate between the rights of adults versus children, then you likely have a significant risk of liability for discrimination based on familial status. And you'll need to take a look and see if the manner in which you're differentiating between adult and children comply with the Fair Housing Act. And I'm not going to get into the further details on it, but I only raise that to give you an idea of something to look at to see, is this something that needs to be evaluated and looked at in more detail? And then the Condominium Act itself has been amended over time. Probably the most significant issue that we see going back on the older documents are with respect to the right to amend the documents themselves. Under the Condominium Act now, under Section 90, if there is a material change being proposed to the condominium bylaws or the master deed, that requires a 2/3 co-owner vote. And there's both an Attorney General opinion and in the Act itself, a provision that says the documents cannot require a higher percentage. And the documents are not supposed to be able to require 100% vote in order to be able to change them. But many older documents have exactly that, especially if you're dealing with rental provisions. So if you have documents which are older than 2001, 2002, and especially if they're older than 1978, you may have a risk of having an amendment provision that does not accurately track the requirements of the Condominium Act. So the main reason for this particular slide is the older your documents are, the more disparity your documents will have with the current status of the law. All right, so this is an insurance question. From a condominium perspective, Article 4 of your condominium bylaws are almost always going to be where your insurance provision is. It's generally not going to be contained in your master deed. It's going to be contained in your bylaws. For those that are in a subdivision, this is probably one of the most underrepresented issues, especially if there's common areas. For whatever reason, many sets of documents ignore outright the obligation or the need of an association to insure common areas in a subdivision context. But here's the question. Joe pays off the land contract and runs for the board of the White House Acres Condominium Association. Joe holds a barbecue and burns down Nancy and Chuck's limited common element decks. The smoke causes damage to Nancy's artwork collection inside of her unit. The bylaws contain the following provisions. 1, the association is responsible for insuring all of the common elements. 2, each co-owner is responsible for repair and replacement of their limited common element deck. 3, each co-owner may obtain insurance with respect to their units and appurtenant limited common elements in an amount they deem fit. Chuck has insurance. Nancy and Joe do not have insurance. What damage is covered under the association's insurance policy? So that's the question. It's kind of hard to put in chat, I realize, but basically the overarching question is, does anybody think that the association has liability under its policy? You got one that says none. Everyone should have insurance. Ian asks if he's currently on the board. No. So this one is pretty messy. So this one is relatively messy. To begin with, Nancy, and this is going to sort of deviate from the question, Nancy can sue Joe for the damage to the artwork, but the association should not have any liability to Nancy for any of the damage under its own insurance or under a repair and maintenance, repair and replacement responsibility. With respect to Chuck, Chuck's insurance should apply to his limited common element deck. However, and that's largely because he's got repair and replacement responsibility. However, there may be a question as to whether his responsibility is only up to the amount of the association insurance deductible and whether the association's insurance would cover the remainder, depending upon whether or not there's a primary coverage provision contained in the documents. And that means an instance where insurance applies to both particular settings. And a primary coverage provision could potentially shift responsibility. But in the example that's been given, Chuck should have responsibility for repair and replacement, and so I would expect it to be his insurance. With respect to Nancy, Nancy will need to, at a minimum, pay the amount of the association's deductible as to her deck, since she doesn't have insurance. And there is a strong possibility and a likelihood that she would have to pay the whole thing, at least in order to be able to restore her deck, because she has repair and maintenance responsibility. Again, however, and I think somebody just made this comment, Nancy can likely pursue Joe for liability because it's arising out of actions on his part. In addition, in one sort of bonus issue is Chuck's insurer and the association's insurer may or may not have a right of subrogation against Joe, depending upon whether such prohibition of subrogation is contained in the bylaws. And there are a couple other provisions that may apply that are sometimes contained dealing with whether or not the association can be liable for incidental damage, which could further limit liability. and whether or not there's a responsibility shifting provision dealing with the arising out of negligence. So this particular answer in this particular dynamic is relatively complicated. The reason that I'm presenting it, though, is to indicate insurance provisions should be reviewed, because as an overarching matter, insurance companies tend to try to avoid paying if their insured is not responsible for the repair. In this particular instance, the association itself was not intended to be primarily responsible for repair and replacement of the decks. And although Chuck insured the deck, Nancy did not, and that could pose issues. In this case, it's a deck, but what if she doesn't have the money to rebuild it? And insurance could be, especially if your insurance provisions are older, but the reasons here to evaluate whether to amend it are whether or not the insurance provisions reflect and are coterminous with two things. One, do the insurance provisions and obligations track the same maintenance, repair, and replacement responsibilities that are set forth in the master deed? And do the insurance responsibilities and the repair and replacement and maintenance responsibilities track the allocation of what is the best, which party is in the best position to be able to care for the particular item? And does it reflect how the association wants those responsibilities to be allocated? So depending upon how your insurance provisions are phrased, if a very simplistic approach has been taken, it may not take into account some of these nuances. So insurance provisions are something that you may want to take a look at. All right, this one is another example. So in our example here, Proposal 1 passes, and Michigan legalizes marijuana. The White House Acres Condominium Association's bylaws are silent on marijuana use. The bylaws contain a provision that prohibits a co-owner from causing a nuisance or engaging in any illegal activity. Blazing Bernie decides to grow 12 plants for personal use in the balcony of his unit, the maximum allowed by Michigan law. The association can see the plants on Bernie's balcony, but the smell does not bother the other co-owners. Smoking Sam does not grow marijuana and prefers to smoke it. All of the neighbors complained to the association about the smell of marijuana in the common element hallway outside of the unit. Question: are the bylaws sufficient to stop Blazing Bernie and Smoking Sam? So that's the question. If the hypothetical is, if you have a board of directors that would like to pursue Blazing Bernie and Smoking Sam, are the bylaws sufficient for them to go after both of them? All right, so we've got a couple yeses. The status of Michigan law has not swayed those that have commented so far. So in this particular issue, notwithstanding the passage and the legalization of marijuana under state law, this is I do have one person that said no, but this is generally a preemption issue. Marijuana use and growing is still a controlled substance, and it's still going to be illegal under federal law. And so the documents are required by the Condominium Act to prohibit illegal activity. And in this case, technically, the illegal activity would be growing and smoking marijuana, which would be illegal under federal law, even though it's been maintained, it's legal under state law. So this is going to pose for many associations and boards, going to put them in a predicament, because for the most part, many associations in this standpoint simply want to stay out of the issue and stay out of the fight between federal and state law, or at least the distinction that exists. What we see many associations do is to take a position that prohibits illegal activity, whether or not it's been legalized under state law, but to say that the association itself cannot face liability if it chooses not to enforce that particular provision. Basically, the way out that we attempt to utilize for associations in this particular provision is to basically duck. If the provision allows, if the bylaws permit the association and the board to do that. However, if the provision is not contained in the bylaws that would allow the association to defer enforcement, then the board would generally be obligated to enforce the bylaws as written. So this particular issue is a little bit of a conundrum for many. And if it comes up in your association, it usually comes up in this context. One, the smell of marijuana, and two, the growing. In both instances, it's still illegal under federal law. In December of 2019, there was an interesting case that came out dealing with smoking, though, not marijuana smoking. But in this particular example, we indicated that there is a generic provision in the bylaws that prevents a co-owner from creating or causing a nuisance. That's a very common provision, and if you're in a condominium, it's almost always going to be the same. And the legal versus illegal status under federal law exists regardless of whether it's for recreational use or medical use. Federal law, at least from a legality standpoint, if it's illegal under federal law, the fact that Michigan law permits it either medically or recreationally isn't going to affect that analysis. But back to cigarette smoking for a second. In the case called Echo Valley, the Michigan Court of Appeals concluded that the nuisance provision cannot generally be used to attempt to prohibit smoking within a condominium. And so if this example, we're dealing with a smoker, a cigarette smoker, that was creating a potential nuisance in the condominium or in the general common elements of the condominium, unless there was a bylaw provision that outright prohibited smoking, or unless the smoking was to such a degree as to create unique circumstances, it would be unlikely that the board of directors would be able to prohibit the individual from smoking if the bylaws did not already prohibit it. So it was an interesting take, but basically what the Court of Appeals said was they said, look, the bylaws don't prohibit smoking, they prohibit nuisances. If you wanted to prohibit smoking, cigarette smoking, you could have done so and you didn't. And unless it is significant enough to actually create a nuisance, you cannot use the nuisance provision generally to attempt to prohibit something you could have done specifically, smoking. So that's a slight distinction, a significant distinction between smoking cigarettes, which are legal, and marijuana usage. The reason this particular slide here, though, is to take a look to see, does the association want to take a position on marijuana that would ease the potential risk for the association and other co-owners if the association wants to take basically a non-position. If you want to take a non-position, then your safest route would be to amend the documents to permit the board to do so. All right, so pets. There are, as I do amendments, there's three categories that are probably the most significant to co-owners and that co-owners get most tied into and get most involved in. The first of these categories are pets. Pets, become part of the family. They're a significant part of a family and they're significant to co-owners. The other two areas are vehicles and rentals. Rentals, the use of rentals and whether you can rent or not, that hits people directly in the pocketbook, so they're very interested. And vehicles deal with the cars that you have, and so people have a significant say in positions on those. But pets are pretty significant themselves. There are many issues that arise with respect to attempts to regulate or restrict pets. And this goes back to the generally the Conlon versus Upton case I mentioned at the very beginning. For example, some of the issues that can deal with pets are whether or not there are pet limits. Are there a specific number of pets that you can have? Are there types of pets that you're limited to? Do you require association approval for pets, or is approval required, or is it just registration or notice? How do you handle the cleanup of pets, whether pets are noisy? Is the commercial use of pets, usually breeding, is that permitted? And must co-owners indemnify the association if their pets damage the either harm another individual, or if they damage aspects of the condominium or subdivision if it's a subdivision? Each of these issues arise from the from the presence and concerns of pets. What a board generally wants to do is to take a look at their pet provision. Do they want to get in the business of regulating and restricting pets? Do they believe that their pet provision is enforceable or not? Or do they want to change it? And the reason I mentioned Conlon is the board is generally going to be, and the other co-owners are going to be stuck with the limitations that exist in the bylaws, the recorded document. If you attempt to use your rules and regulations to expand the types of restrictions or to further limit the ability of co-owners to use pets, that's probably not likely to succeed unless you can be perceived to be either interpreting existing restrictions or implementing existing restrictions. So pet provisions are something that are important to at least know what restrictions exist. So let's take a look at an example and see how people think this would pan out. So we've got poultry-loving Pete is a millennial that is into alternative pets. Who is into alternative pets? He is unhappy with his job and decides that a pet hen will make him happy. He has not been diagnosed with depression. Pete lives in the White House Acres condominium that has the following bylaw provision. Household pets. No animals, birds, poultry shall be kept or maintained on any lot except recognized household pets which may be kept thereon in reasonable numbers as pets for the pleasure and use of the occupants, but not for any commercial use or purpose. All right, so here's the question. With respect to this particular poultry-loving Pete, can Pete have a pet hen? And what if Pete has a diagnosis? So that's the question. So we've got one individual that said, no, Pete cannot have a pet hen. All right, we've got two individuals that said yes, and generally most people are saying no. All right, so here's the issue. So this example comes out of a case, and believe it or not, it really turns on in the case that this was in, the term recognized, except recognized household pets. Who recognizes the household pet? Poultry-loving Pete is going to say, I recognize him as my household pet. And the association would say, or the board would say, but of course that was meant that we have to recognize it, or it's universally recognized as a household pet. However, the documents don't say it. It just says except recognized household pets. And it's possible that the term recognized household pet could be termed vague and difficult to enforce. And if it is considered vague, the term recognized, if it's considered vague, it is possible that a hen, if it's recognized as a household pet and kept for the pleasure and use of the occupants, could actually be considered a household pet, which was actually the result in the New Mexico case. The hen in that particular case, because of the vagueness associated with the term recognized, was considered to be a household pet, notwithstanding the fact that there was already a limitation on animals, birds, or poultry. So in this particular case, it was recognized as a household pet. The reason this particular provision is here is in the previous slide, I had said, take a look at your restrictions with respect to pets, and does it reflect what you want? What I should really say is, does it clearly reflect what you want, and does it clearly reflect what a third party could use to enforce the documents? In this example that we gave, a hen might not be considered a recognized household pet, but it could be if it if that term recognized is considered vague enough, and it might be allowed. And so the term recognized may be too vague. So the issue on this one is, even in the absence of an emotional support hen concept, that animal might be allowed even without a diagnosis. All right, so what if there was a diagnosis? Let's just say, for example, that the association wins on the recognized household pets language and gets a friendly judge that says, no, it's not a dog, it's not a cat, it's not a hamster, it's not an ordinarily recognized household pet. So no, you have no hen. And he comes up with an effort to try to get it qualified as an emotional support animal, or he, in essence, asks for reasonable accommodation. That's really going to turn on the specifics and facts of the case. It is theoretically possible that it could be recognized as an emotional support animal. Recently, at the end of January, HUD just came out with guidelines in an effort to try to provide association property managers with guidance on how to handle requests for accommodation with respect to animals. In the context of those guidelines that were put out at the end of January, basically what HUD recognized was that there were internet form letters that were being used, that could be purchased, that were being used to attempt to obtain quote unquote doctor supported requests for reasonable accommodation. But generally the overarching guidelines that HUD gave in those guidelines was to say, look, if you've got a doctor's note, it's got to be with personal knowledge. Internet form letters really aren't supposed to be sufficient. The doctor really should be providing information based upon personal knowledge. They're going to be more restrictive of non-household type animals. So this hen example that is in this particular case, the guidelines state the association and board making the decision may be more restrictive. However, they cautioned that a formal written request is not required by the individual making the request. An oral request can be sufficient. And they also cautioned that the request itself does not necessarily have to take place prior to the purchase of the animal. The request can come in before or after the individual gets the animal. So there, if you're interested in the particular in the federal guideline, let me know offline. I can let you know what it was, but it is an attempt by HUD to provide some additional guidance to associations in making decisions on support animals. For purposes of our example here, it's possible. It does depend upon what he comes up with, but the general question of whether it's going to be a reasonable accommodation is going to be done on a case-by-case basis. All right, so I am going to cheat on one particular issue rather than saving it to the end. I was asked about breeds such as pit bulls. So there are generally two ways that the condominium bylaws or other bylaws attempt to restrict the types of animals such as dogs in their documents. One is through breed, a type of breed, and another is through height or weight restrictions, meaning you can only have a dog of a certain size or less than 35 pounds. As between those two methods, meaning by breed or by height or weight, the Michigan Court of Appeals has ruled in a case called Bear Creek that height weight restrictions are unreasonable. So if you have bylaws which attempt to limit the types of dogs or types of animals by weight, then it's possible and likely that that particular limitation is not enforceable, especially if the co-owner involved isn't tuned to this Bear Creek case. Bear Creek, however, did not weigh in on breeds. At least as of now, I am unaware of any case that says that you cannot limit breeds, you cannot limit dogs by breed. And so at least with respect to that particular question, limiting animals by breed, limiting dogs by breed is not something that is currently prohibited. And it is something that you can do. However, I would indicate that there is an overarching principle that each association, each board must act reasonably. And so the safest way for an association to operate within those confines is to tie any restriction to a reasonable distinction and not to fall into the trap that the board fell into in Bear Creek, because in that particular case, the board was unable to point to a reasonable reason to differentiate between animals of different sizes. So if you are going to differentiate between breeds, I would suggest that you at least have a basis for that distinction, grounded in observable and reasonable facts. All right, rental issues. So with respect to rental issues, and this is kind of the second of the three categories that people get very fired up at association meetings when we're looking at amendments. Here's the first example. White House Acres bylaws state that units are to be used only for residential use. The bylaws prohibit commercial activity except for home-based businesses with no customers. The bylaws do not prohibit rentals. Joe decides to list his unit on Airbnb to obtain extra income for his political future. Can Joe rent his unit on Airbnb? All right, so we've got one no. We've got another no, open all caps, so that's a really big no. All right, couple no's. I'll give it a little bit more. Now it's interesting. We have probably a lot of board members on this, and the board members I think are going to tend towards no, and some co-owners, especially rental co-owners, can say, well, yes, of course, rentals are not prohibited, which is what somebody indicated. But the answer in this is not necessarily as clear cut as you would think. However, the limitation only for residential use and the prohibition of commercial activity should be sufficient together to be able to prevent the use of a unit for Airbnb, especially if it's only being used for Airbnb purposes. If it's only being used for Airbnb purposes, then that's going to present a significant issue in the context of the no commercial activity. And if it is only being used for short-term use, consistently for short-term use, then it's going to pose issues for that particular co-owner because he's going to have difficulty satisfying the definition of residential use. There was a case called O'Connor. I forget the date, but I believe it was 1999. In essence, the O'Connor case indicated that a residence is where you come back to, where you leave your golf clubs. And so the more the use of the property is going to reflect residential use, the more difficult it will be to prevent that particular use. And with respect to commercial activity, in essence, if the renting is incidental, if the unit, for example, is primarily being used for residential use and only incidentally being leased out, then it's possible that that particular co-owner could have an argument that they can use it. Under the facts as presented in this particular case, though, I do think that the association should be successful in being able to prevent the use of Airbnb using solely the residential use and commercial activity restrictions. This particular issue is, as you can imagine, pretty rife with controversy, and there are a number of interested parties on both sides that would like it to come out in their particular side. You have a lot of individuals that buy units solely for the purpose of renting them out, and then you have homeowners who maybe live there, and maybe they're on the lake, maybe they're on a golf course, that maybe want to lease them out at short periods of time, maybe for a weekend. These are really done and evaluated on a case-by-case basis. The absence of clarity in your rental provisions is what is going to cause the problem. This particular example is presented here not necessarily to identify the status of the law, but to identify the potential issues that might arise if your documents do not provide clarity with respect to the rental, whether it's long-term or short-term. So the purpose of this is to encourage each of you to take a look at your rental provisions and see if they reflect what you would like to see from a rental standpoint. Unique to short-term rentals, there are a couple different ways that these come about. There are a couple different reasons, and a couple different ways they're handled. I've already mentioned commercial use and residential use. Short-term rentals tend to be able to be blocked if they are not being used for residential use, if they're continually being used for 2 to 3 night stays, for example, and commercial use if they're solely being used for Airbnb. However, both of those tools as a means to prohibit the rental become less effective the more the use of the property reflects actual residential use and the less of a solely commercial use for the property. And that's generally a distinction that exists between short-term rentals and long-term rentals in many instances. In some instances, they can constitute a nuisance, and in some instances, they can be unlawful if they conflict with local zoning ordinances. This issue from a zoning standpoint and from a legality standpoint is not necessarily up in the air, but is somewhat up in the air because there have been several efforts, especially on the west side of the state, to attempt to force municipalities to prohibit them from being able to restrict Airbnb type short-term rentals. That issue is, we'll see how it all plays out in the long run, but short-term rentals are definitely an issue. They're not going to go away in the short term. Basically, it provides too much money to people that have condominium units that are in vacation type places. From an amendment standpoint, if you end up amending your documents to prohibit short-term rentals or address them, there are a couple of different things that we like to see based upon how people have tried to circumvent, the different restrictions. One of them is to include a prohibition of licensing, which would be a use that can be non-exclusive with somebody else, but licensing in addition to renting and leasing, and prohibiting the listing of the unit. The listing of the unit, if the documents only prevent or prohibit the actual rental, it may be difficult to enforce, even if you know the person has it listed for rent. But if the prohibition exists, the prohibition of the listing of the unit could be a source of an independent source of a bylaw infraction. All right, so those were some issues that were somewhat unique to short-term rentals, largely because of the significance of the issue over the past several years. However, with rentals in general, there are a couple things to keep in mind. One, whether it's for short-term or long-term rentals, do you have a rental cap? Do you want to have a rental cap? A rental cap can be significant because depending upon whether or not you have, and rental caps that we like to see are generally at least 30%, but basically under a condominium bylaw provision requiring amendments to rental provisions would require a 2/3 co-owner vote. But if the number of rentals in a condominium exceed 30%, then that may make it very difficult to have enough co-owners vote in favor of the limitation. So if you are seeking to investigate the possibility of imposing a rental cap, we do suggest trying to do so before the rentals get out of hand and it becomes nearly impossible to regulate. Now, in some instances, we can avoid this through the use of grandfather clauses, which can sometimes create an incentive for landlords to vote in favor of a rental restriction. But as a general matter, we do like to see the co-owners make a decision on this prior to the time that rentals get above 30%. The two other provisions that must be contained, and these are derived from Section 112 of the Condominium Act, MCL 59.212. The condominium association is supposed to have independent rights related to the regulation of rentals, setting aside whether or not they can approve the existence of a rental or whether there's a rental cap. Under Section 112 or 59.212, co-owners must disclose the leasing of their unit 10 days in advance, and they're to provide a written lease to or co-owner information if there is no written lease to the association. In addition to that, the Condominium Act requires that the bylaws are supposed to contain a provision that says if the co-owner, the landlord co-owner, fails to pay their assessments, then the association board of directors is entitled to, through rent diversion, require the tenant, the tenant who doesn't own the unit, but renting from the co-owner landlord, that the tenant must divert rent otherwise intended for the co-owner landlord to the board of directors. And these provisions are supposed to be contained by statute. If they are not in the statute, there's something to take a look at and evaluate in order to basically address the rentals. So the purpose here would be to evaluate whether your documents contain adequate provisions regarding rentals. All right, so a couple other issues with respect to the bylaws themselves and different issues that may arise. So this one is a little bit based on what we've been talking about, somewhat out of left field, but here it is. So this deals with smartphones, social media, and website use, kind of a modern day problem. Hillary lives in the White House Acres condominium. Hillary really wanted to be the association president, but lost to Don in the last election. Hillary is contemplating whether to run for the board again. Hillary shows up at a board meeting to make trouble. The board is discussing a roofing contract. One of the options is Don's friend, Tony. Tony's quote is $50,000 cheaper than all other quotes. Hillary records part of the conversation, creates a website called whitehouseacres.net, and posts the recording on the website in a fake association Facebook page that she created. What are the association's options in this particular setting? Anybody want to take a stab at it? Yes, Bill gets it correct. The answer, of course, is call hers a law. But maybe we have a board that chooses not to call hers a law. All right, so we've got one individual with a cease and desist. So this one is here because ideally, from a proactive matter, the board generally should have the ability to regulate the conduct of its board meetings. And board meetings are not, private board meetings are not subject to the Open Meetings Act. So whether the board decides to allow non-board member residents or co-owners to attend, generally that's going to be a decision up to the board. The Open Meetings Act does not apply. So the board could have adopted a rule either limiting the use of electronics or even preventing members from attending if done ahead of time. However, in the absence of a provision, if the board did not do any of those steps, in the absence of a provision prohibiting or limiting this type of activity, the board's actions are pretty limited unless the board can demonstrate that the fake website was intended to deceive the public into thinking it was the real website. One of the reasons we have this here is from somewhat of a self-serving standpoint, of course, but from the perspective of the board, one of the provisions we include is a provision that attempts to give the board the ability to control its voice and control its message and names that are similar to its own association name, and to authorize or to require board authorization if there is a member that is attempting to either usurp that authority or to make it seem as though there's a competing or shadow board. So without that type of provision, it can get messy. The issue here is whether or not it exists and whether the board took proactive steps. But so takeaway, board not subject to the Open Meetings Act. Board could have simply allowed it to be board members. Board is generally allowed to adopt rules and regulations regarding the conduct of board meetings, so they could have done that ahead of time. In the absence of both of those, they would ideally look to a provision in the bylaws that limit the members' ability to record board meetings or to disseminate those recordings. All right, so there's a couple slides that I have in here that originated out of steps that we've taken and things that we've done dealing with coronavirus and COVID-19. So early on, we had talked about, or I had talked about the Conlon versus Upton case and the need for restrictions to be anchored in or to be based in existing restrictions contained in the bylaws. And these 3 points here are different provisions that in theory should be able to be used by a board if a board is attempting to adopt rules and regulations to guide itself in the conduct of its members during this the quarantine period imposed by the various executive orders and the recommendations of the CDC. And these particular examples here are in many instances condominium documents and sometimes even homeowner association or subdivision declarations will require a co-owner to maintain their unit and their limited common element that they have a responsibility for in a safe, clean, and sanitary condition. And that term could potentially give an association, I'll use the term anchor again, but a basis upon which to require steps to be taken to make sure things are safe, clean, and sanitary. In addition, some documents allow association to take steps to protect the health, safety, and welfare of the residents. Now, again, couched and limited by the reasonableness of a board of directors, this provision can in theory be used to adopt rules and regulations that when compared against, or at least when used in conjunction with existing executive orders to help guide the actions of the co-owners or members and potential limitations on activity and conduct within the condominium. In addition, there will be different provisions, and we've already seen one in the context of the federal preemption rules on illegal usage of marijuana, but the terms noxious and illegal. Illegality, a misdemeanor, is still illegal, and the executive orders that have been adopted are in general misdemeanors, but they still impose binding law. And so rules adopted in reliance upon the requirement that nothing be done illegally could be used to help guide actions of the co-owners. And the term noxious generally means, if you think of noxious, think of poisonous or dangerous, like noxious gas. That term noxious in theory could be used to assist in prohibiting the noxious activity in the units and uncommon elements. Each of these, though, again, if they're being used, need to be used reasonably and need to be used in a manner that reflect an attempt to, again, interpret and implement these restrictions in a reasonable way, given the current circumstances that the board finds itself. These are in the sections dealing with bylaws, though, because they can be useful, and they're examples that you can see. And most likely, the first bullet point and the third bullet point are likely already contained. The second bullet point may or may not be contained. All right, so with respect to general enforcement issues, there are just a couple of different things I wanted to go over when dealing with the bylaws and restrictions and some common ones. So one of the things that we see generally are the importance of uniform enforcement of assessments, or improperly imposing assessments, maybe attempting to impose a special assessment without conducting a co-owner vote. In many instances, the condominium documents will differentiate between regular, I'll call them annual/monthly assessments, and they'll have another category of additional assessments, and then they'll have another category of special assessments. The most common ways these are addressed is the additional assessments, which are usually for unexpected repair and replacement costs, generally don't require a co-owner vote, but special assessments do require a co-owner vote, and they will be and the things that are subject to, or the items subject to that co-owner vote are going to be defined in the assessment provisions of your bylaws. So on this particular issue, we would encourage you to review the assessment provisions and the distinctions between additional assessments, regular assessments, and special assessments, and ensure that you're giving the board the flexibility it needs to be able to impose the assessments necessary to fund the full operation of the condominium or subdivision, but also reserving to the co-owners the right to weigh in on those things that under the sensibilities of that particular condominium or subdivision wish to be reserved to the co-owners. With respect to attorney's fees, a couple of the things that we see are that depending upon the age of the documents, especially in documents that were drafted in the 60s and 70s and even early 80s, and especially dealing with declarations as opposed to condominium bylaws, for whatever reason, the declarations really were averse to imposing attorney's fees on the co-owner or on the lot owner. So attorney's fees provisions in many cases are not even contained in declarations from the 70s and early 80s. And even if they are contained in later documents, including condominium bylaws, they may be limited to instances where the association has been successful in a lawsuit or post-litigation litigation fees. So the question that's being presented in this particular bullet point is, from the perspective of the association, if the association incurs attorney's fees, can the association assess those costs? Does it want to assess those costs against the co-owner responsible, even if it does not lead to litigation? You may be surprised if you believe that you can always assess the unit the attorney's fees incurred in investigating a potential bylaw violation, but in many cases that's not the case. So it's something that you'll want to take a look at. With respect to fines, fines are somewhat interesting because fines are a very easy and useful tool to boards to use when they attempt to bring co-owners in line to comply with the bylaws. Bylaws are to be uniformly enforced when somebody is in violation. Ideally, there is a tool for the association and the board of directors to enforce them without having to resort to court, and a fine is a way to do that. However, there are two issues that we tend to see. One is, in some instances, the declaration or the bylaws, usually not the bylaws, but many instances, it's the declaration, private subdivisions, doesn't even permit fines, or permits fines only in certain circumstances. A fine, if you are evaluating a case in a set of restrictions under Conlon versus Upton, fines really should be imposed only in those instances where a co-owner or lot owner buying into the subdivision is on, or condominium is on record notice of the possibility of a fine, such that they're aware of that possibility. And the other issue that we see with respect to fines is whether or not the board imposes a fine automatically, or whether the board gives the co-owner a hearing, which would simply be usually a board meeting, to give the co-owner an opportunity to present their side of the case and explain why no default occurred and no fine should be imposed. What we like to see are that the bylaws themselves both permit a fine, they require the board to hold a hearing to give that co-owner the option of attending, but they also give the board the ability to change fines by rule. That, to us, gives the board flexibility, and it protects the co-owner and ultimately the board if the board does impose a fine, because it gives the co-owner an opportunity to contest it. In many cases, the co-owner will not attend. In some cases, they will. But if your documents either do not permit a fine expressly, or if they don't require a hearing, then you may want to consider evaluating whether that particular provision should be amended. And then the same issue with fines also goes with interest and late fees. Do your documents permit them to be imposed? And do your documents allow the imposition of those if there's non-payment, and when? One particular issue that we see here on interest and late fees are whether or not there's an order of payment provision. Ideally, there is an order of payment provision that allows the association to take a payment of an assessment, to take a payment from a co-owner, and to apply it first against interest, late fees, fines, and attorney's fees, and then only after those have been paid to assessments in the order in which they've been incurred. Because if you don't have that type of provision, what you might have is you may have a creative co-owner who sends in a check payment that says to be allocated exclusively against the March 2020 assessments, even though they've got $15,000 in late fees. And in that particular instance, without the order of payment provision, you just have some decision making to do. But each of these issues are issues that can be streamlined and made much easier if the documents are accurately described correctly. And in general, so those are the issues that we tend to see from a bylaw standpoint, some from an amendment in the bylaw standpoint. Many of these also apply with respect to the declaration. Some of them are somewhat unique to the condominium. But at this point, what I would take is I will take some, if you have questions on bylaws, I will take them in chat for the next couple minutes. I do have one that says, isn't a hearing required by the Michigan Condominium Act? Yes, that is our interpretation of the Michigan Condominium Act, is it does require a hearing, and we advise our clients. What I'm getting at with respect to this particular issue is solely in the context of what's contained in your documents. If the documents do not expressly require a hearing, and a very diligent board is going about their business and adhering to the letter of the bylaws, it is possible that a board can misunderstand their legal obligations, follow the requirements of the bylaws, and impose a fine without a hearing, even though they're required to do so prior to the imposition of a fine under the Condominium Act. Timing of fines assessed prior to hearing. So I guess the way I'll respond to that particular question is you should not be imposing, at least in my view, a fine until after the hearing takes place and the co-owner has been given the opportunity to contest the default. In many cases, the first notice of default is done without a fine. And in that particular case, there's no particular reason for a hearing, although you can have one. However, if you choose to impose a fine, then our recommendation would be, and hopefully it's contained in your documents, that a board meeting takes place. And yes, will these slides be available to download? The entire presentation itself will be available along with the PowerPoint itself. All right, so I'll probably give it about 30 more seconds on the bylaw questions. For my comments, the question is, with my comments, the one thing I need to apologize for, you will, to get my comments on the slides, you would get the privilege of being able to watch the video again and again and again. So you would get the slides, but for my commentary, you would need to watch the video. All right, one issue I actually didn't necessarily cover by slides, but I would like to weigh in on very quickly is vehicles. Vehicles, when I do presentations to association meetings on a document amendment process, vehicles are the third of the three categories that get the most comments, with rentals and pets being the others. In general, consistent with how you're hopefully gathering our views of Conlon versus Upton, if you are imposing restrictions on parking of vehicles or the use of vehicles, those types of restrictions should be contained and anchored in the bylaws themselves. Ideally, you have bylaws that reflect what you want to see by way of restrictions in parking, but that authorize the adoption of rules and regulations to give the board flexibility in adopting things as time change. I just wanted to quickly mention that on vehicles. And then lastly, with respect to amendments themselves, we generally see two types of amendments. I'll call the first set of amendments spot amendments, and the second set of amendments amended and restated documents. For those of you that maybe have come to us and asked for a quote for documents, what I tend to do is to break that quote and that description down into a distinction between spot amendments and amended and restated documents. Spot amendments are instances where the board or the association is only changing one or two things. Maybe they only want to do change an amendment, the rental provision or a vehicle provision or pets. An amended and restated set of documents is going to be an instance where the association redoes the entirety of their documents and it reflects an entirely new set, largely incorporating the character and flavor of the community from the original documents and those provisions that are necessary to carry over, but fully updating and then including those provisions that are sought to be incorporated that may have changed over time or that maybe the association wants to do. In many instances, we actually see that amended and restated is cost effective. If you have a lot of amendments, you have a lot of things that want to change. If you have very few amendments, then spot amendments can be effective also and cost effective. But as you can imagine, the more spot amendments you intend to incorporate or the more things you're trying to change, the more the needle ends up pointing towards an amended and restated set of documents. But generally, you've got two types: changing one or two small things, or completely redoing your documents. All right, so rules and regulations. And this is the third category of the three types of amendments that I wanted to go over. Again, Conlon is the second, rules and regulations are really the second component of the Conlon versus Upton case. Rules and regulations should be used by the association to implement and interpret existing restrictions and existing bylaws. Ultimately, does the rulemaking authority exist for the association? If it's exceeding either its rulemaking authority or it's exceeding or the existing restrictions or imposing new restrictions, then that's going to be an issue for the board. These are usually done if you need to impose new restrictions. Those are usually done by need to amend the bylaws or the declaration. But adopting rules and regulations, assuming the authority exists, is something that's going to be done at the board's discretion at the board level without the co-owners needing to weigh in on it for the most part. In some instances, you will have documents that will give the association members the right to revoke them in some cases. In very few cases, they require association approval, but those are, excuse me, member approval, but those are very rare, and I haven't actually even seen those be implemented. All right, so with respect to the first example that we're going to do under the rules and regulations, White House Acres Association bylaws require the association to maintain, repair, and replace the limited common element front door of each unit. The bylaws also permit the board to adopt rules regarding the appearance of the condominium. Don convinces Nancy and Chuck to adopt a rule requiring that all front doors be painted brown. Alexandria refuses to paint her front door brown. Is this rule enforceable? So how many people want to weigh in on whether this particular rule as drafted is enforceable? Now I'm going to cheat, and I'm going to let you know that this is somewhat of a trick question. All right, so cats out of the bag to a certain extent. We've had one individual respond who indicated who got the trick. There's really two things that are being asked here. One of them is repair and responsibility. No, the association cannot shift the obligation to maintain, repair, and replace the limited common element front door to the individual co-owner. So to the extent that the association is attempting to have the co-owner actually maintain, repair, or replace the front door, that is something that the association cannot do. However, the association does maintain the authority to dictate the color of the front door. So if all the association had done was indicate that front doors must be painted brown and then proceeded to undertake that responsibility and only enforce the rule against co-owners that attempt to change it to a different color, in that scenario, the rule would have been fine. In this particular question, as drafted though, the board is attempting to have the co-owner do it themselves, which is the improper reallocation of responsibility. Now, I know this question is probably a little bit unfair, but it's intended to highlight one of the things that we do see trip up the board. If the association has the obligation to maintain, repair, and replace something, that means it's the association's responsibility to do it. The fact that you control how something appears, and the fact that it might appear as though it's something within the control of the co-owner doesn't necessarily shift that responsibility to the co-owner. So be careful with the rules that you adopt. Don't exceed the authority. And in this particular instance, while the substance of the request generally would have been okay, the manner in which they attempted to pursue it did not work out. So in this particular instance, the rule would not have been valid because it improperly shifted responsibility. So this question was a question of cost allocation as opposed to who can dictate the color. For those that were answering based on the premise only that it was on whether the board could dictate the color, you're right in that respect, but be careful about an improper cost shifting that would violate the existing restrictions. All right, so this next slide is the rule equivalent of what we saw earlier in the bylaws. These are different issues that we see arising that are more going to be faced by boards presently that deal with the operation of the condominium. And these are some things that we've seen come up. So for the first part, depending upon the nature of your condominium, if you are a site condo, some of these are not going to really be applicable because you're going to have what people will see as individual homes with very little person-to-person contact. Many of our clients, many condominiums are condominiums, however, that exist in a single building where you can't get from one unit to the other without passing through a common hallway, or that have a general common element, gyms or pools. In those particular instances, if the correct provisions exist or useful provisions exist that I mentioned in the bylaws, the areas that we see that can be contemplated to have rules restricting access to include limiting access to general common elements to residents or co-owners, subject to certain exceptions, for example, for medical necessity, or outright closing common recreational facilities. In large part, some of the impetus behind this is going to be the sanitary provisions in the bylaws, the obligation to maintain the clean and sanitary units, limited common elements, general common elements. And in other cases, it's going to be using the executive orders themselves and implementing the executive orders through rules so people actually recognize what is going on within the particular community. Again, there is an underlying requirement that the rule implement or interpret existing restrictions. But as long as the board is able to point to or anchor a rule in an existing restriction, such as illegality, the board should be able to implement the executive orders currently in place and potentially go beyond those if it's at least consistent with and being anchored in the existing restrictions. Three other things to mention on these. From an enforcement standpoint, if you adopt rules along those lines, the difficulty is going to be enforcing them. You will probably need to use the fine mechanism if you have it through remote communications and remote board meetings, which I'll get to in a second, which would be obviously holding a hearing before a fine. But your recourse and ability to resort to the filing of a lawsuit, at least at this point in time, is probably very limited. Courts, like almost every other employer and every other area or facility, has very limited availability. I had a question, should tennis courts be closed at this time? I can't necessarily weigh in on what you should or should not do. What I would do is encourage you to review the executive order that came out on Monday that went into effect on midnight at Tuesday, and whether or not that is a recreational facility that would be subject to the order, and or whether it fits within one of the exceptions. There are a number of exceptions, including for hikes, and for example, if there are common walkways or pathways that may be difficult to close, but whether or not the tennis court is going to be equivalent to a gym or a pool, that you'll need to take a look at that on your own. But I would be cautious and I would evaluate the executive order from Monday. But my point on the enforcement issue is to let you know that you should generally view it now as the board being on its own, the association being on its own. Frankly, there are bigger issues right now for courts and police than enforcing these at a lower level. And so I would just take that into account. And I would expect the usual tools of enforcement, being court, injunction, to be not as available as they've been even in the more recent past. So remote meetings. In many cases, amendments to for example, with the action without meeting, but amendments to the Nonprofit Corporation Act that streamlined or made more efficient the operation of a corporation required an actual physical change to the condominium documents, either the articles of incorporation or the association bylaws. However, remote meetings and remote communication is not one of those things. So the boards still have the ability under MCL 450.2405 for association meetings and MCL 450.2521 for board meetings to hold meetings by remote communication, which would permit you to have a board meeting or association meeting not unlike the meeting that we're having now. However, there are a couple things to keep in mind if you choose to have a remote meeting, whether a remote special meeting or an annual meeting. First, if your documents prohibit that conduct, then your documents will control. The ability to conduct meetings by remote communication exists as long as contractually the members of a corporation have not agreed otherwise. But assuming that you are able to conduct a meeting by remote communication, the notice itself must, at least with respect to member meetings, the notice must state that it's going to be remote. The board can adopt reasonable guidelines regarding the conduct of the meeting. The board must also take measures to ensure that the participant in the remote meeting is actually a co-owner, that each co-owner has a reasonable opportunity to participate, In this instance, the use of chat is one mechanism, but if we were to conduct a meeting, we would have to make a decision as to whether to open up the mics to use by other parties or whether to coordinate a continuity between the chat and the mic method. But it would probably not be able to mute everybody at all times like we've done on this call. And lastly, if a meeting by remote participation has been done, then the association must maintain a record of the action. And then lastly, for purposes of remote participation in a member meeting, attendance by remote communication is considered attendance by that individual. And somewhat the same goes for board meetings. Board meetings 450.2521 can also be done remotely. Those can be done by teleconference also. And you'll all be disappointed to know I recognize I've only got a couple more slides. So lastly, on collection policies, the reason we have collection policies here is because we do anticipate that there will be a rise in delinquencies because of the financial impact of the coronavirus on employers, people's jobs, and people's ability to pay collections or pay assessments, excuse me. With respect to collections, though, we have several recommendations. The overarching recommendation is that, one, you still must treat all co-owners equally. We do encourage, at least at this present time, modified collection policies to take into account the current situation. We also encourage our associations not to stop liens, to still maintain liens, but the presence of a lien does not automatically mean foreclosure, but a lien can assist in negotiating, and a lien, the policy can be revisited at a later date if the lien exists. In addition, high delinquencies can affect negatively either a future co-owner's ability to obtain financing, especially if there's an effort to obtain FHA certification, and if an association is seeking to obtain a loan, the ability to qualify for a loan. We do at present, CAI also recommends that foreclosure be delayed and that associations look into the possibility of payment plans and the possibility of waiving interest if waiving interest is permitted by the bylaws. So rules and the use of rules can be an effective tool to assist an association and board in navigating the difficulty in payment of assessments that co-owners are expected to have. All right, so the last slide, the last substantive slide, deals with other types of common rules that we see. A board can, if they don't have these rules and they would like to approach or adopt a commonality, we see slides on aesthetic issues, meaning how things are intended to appear, not just architectural control, but colors, fences, side colors, roofing, that kind of thing, if that type of control is permitted under the governing documents. Bylaw enforcement policies can help. Board members' code of ethics can help. In some cases, it can help board members dealing with one another. Sometimes the democratic process can be messy, and however, the messiness that comes out of it usually leads to a good product, but a code of ethics can, in many cases, help board members help navigate that particular issue. Collection policies we've gone over, that can help maintain continuity, and it can help demonstrate to co-owners a sense of fairness when there's a uniformity of policy or uniformity in efforts to collect. We've already gone over the fine policy. With respect to a fair housing policy, what I would just suggest is that a fair housing policy can help the association if it's attempting to eliminate or prohibiting discrimination either in race or familial status are two common areas. With the fine policy, I know I already mentioned it, but that again can help with establishing uniformity and commonality and demonstrating to co-owners that the board treats everybody equally. So at least with respect to what we have, Those are the three areas where we see the amendments to be most significant. Articles of incorporation, which are done by votes of the members of the corporation, the governing documents, which deal with the recorded documents, and placing the co-owners on record notice of those restrictions, and the use by boards of directors to implement those restrictions through the adoption of rules and regulations, which can help, sometimes it's called filling in the gaps, but generally help provide the nuances that don't exist in the restrictions. So I will open up the chat to the last series of questions if anybody has questions either about rules and regulations generally, or if they have questions about the other two topics. You're welcome. I hope it was informative, and I hope you got a lot out of it, and I hope guides how the boards can conduct business. How to properly notify of a fine in a hearing. Okay, so there is a question regarding how to notify a co-owner of a fine or a hearing. So there are really going to be two ways to go about it. In many cases, the Nonprofit Act permits an association to provide electronic notice, for example, emailing somebody. However, electronic notice, at least in our interpretation under the Act, is only permitted if it's been authorized by that particular co-owner. So, and it's easy, it's efficient, it saves money. But if a co-owner has authorized electronic notice, meaning email communications, then one method is to email them. However, if a co-owner has not authorized or owner has not authorized the use of electronic communication, then you would need to resort to the notice provision contained in the bylaws, which is either going to, usually it's going to be first-class mail. In some cases, it may be certified mail. In some cases, it may even be hand delivery, although it's most likely going to be by first-class mail. But I would look at the notice provision contained in what I'll term the association bylaws. Do you have to inform anyone of changing the bylaws? Yes, there are two things that you need to consider. One is the condominium bylaws for a condominium are generally comprised of two things. One, the condominium bylaws, which are those required by the Act dealing with insurance and restrictions and a repair and replacement in case of insured casualty, and then what I'll call the association bylaws. The association bylaws being those portions of the condominium bylaws that dictate when member meetings can take place, the powers of the board of directors, the notice provision, and different officers. In many cases, those association bylaws are outside of the condominium bylaws, or it may be done as separate documents. However you choose to amend and provide notice of the amendments of the association bylaws, that must be in conformity with the language of the association bylaws. With respect to the condominium bylaws, if you are amending the condominium bylaws, you must, one, provide notice of the actual vote in accordance with the notice provisions of the document, and then the amendment itself, the period of voting is usually going to be between 10 and 60 days or 20 and 90 days. In any case, though, for the condominium bylaws, the bylaws themselves cannot be recorded until at least the co-owner has been given 10 days to look at them, or they've been given to them in at least 10 days notice. What we tend to do is to, at the same time, the notice of the vote and a ballot goes out, or a notice of meeting, if it's going to be the meeting, is we provide an actual physical copy of the proposed amendment so everybody knows the exact thing that's being voted on. As far as the exact wording for the fine, a notice of the fine, that would really be dictated by the by your bylaws. In general, you're going to want to provide the individual with the factual circumstances of the alleged violation sufficient for them to be able to determine whether or not they can contest it or not. You would want to give them notice of the circumstances of the violation and also the date and time of the upcoming meeting, and then the consequences of showing up or not showing up. In any case, though, and in most cases, the bylaw provisions regarding fines and default will contain those requirements. Another question is, can an association outlaw satellite dishes? We somewhat covered that when we went over the Otard law. I would just reiterate that if you have a provision that purports to give the board the ability to outright prohibit satellite dishes, you will likely have issues because you likely don't have that right as it relates to the units and limited common elements. And as you can imagine, that's thanks to Dish Network and DirecTV. Residency, okay, so the question is, are residency requirements common to be eligible to vote? And I'm assuming what you're asking is, can the vote be limited to resident co-owners, not absentee co-owners or landlord co-owners? I would have to say that is not common. If your question is whether or not it's common, I would say it's generally not. And if you think about it for a second, the association itself is formed up of members of the corporation. And in general, membership is determined by ownership. And however you exercise that ownership, whether it's as a landlord, if you're permitted to do so, or as a co-owner, you're still a member. And you still would have the ability to weigh in on, in general, how that ship, how that association navigates the waters of this corporate being. And so if the question is whether it would be common to preclude absentee owners from voting, I would have to say that's not common, at least in my experience. And I would likely not advocate for that. So I'll probably give it another minute to see if anybody else has any additional questions. Again, feel free, if you do have questions and would like to talk to me offline, feel free to email me. Here is my email. Feel free to call also if it's after hours. For example, if it's now, I'll get back to you as quickly as I can. But feel free to contact me with any questions. With respect to credit, I'll talk to you afterwards. So we'll need to talk offline about that. But thank you for attending, and it will be available up on our website. Thank you, everybody. Have a good night and stay safe.